To my right is the Honorable Gilbert Roman, and to my left is the Honorable Lino Lipinski. And we constitute Division 4 for the purposes of today's oral argument. There is only one oral argument on today's docket, Rocky Mountain Hydro versus Walsh Construction, and I assume that counsel is here for that case. I have a couple of questions to ask and then a request, and then we'll get on with oral argument. The question is, are both counsel familiar with the instructions for oral argument? Yes, sir.
The ones that were sent yesterday?
Yes, yes, sir. You realize that each side has 15 minutes?
Yes, sir.
Okay, I would ask that everybody in the, and by the way, you are responsible as the appellant for your own time. I will not remind you. If you want to save a certain amount, I won't interrupt and remind you so that you can do that. You've got to be able to watch for that. I would also ask folks who are in the courtroom, please, 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 if you have a cell phone or a pager that might go off, don't just put it to silent, please turn it off. And the reason that we ask you to turn it off is that there is something, and remember I'm a lawyer, not an electrical engineer, so I don't know how to explain this, but there is something about the field that cell phones generate that can interfere with our recording devices in here. This argument will be live streamed and recorded for our video archives. And because it is live streamed, please don't say anything that is confidential, because it will literally go out to the whole world immediately, and we won't be able to bring it back. So if there's any information in this case that you don't want the world to know, let's please not talk about it today. That being said, we are ready for oral argument. Counsel, please proceed.
Good afternoon, Your Honors. Daniel W. Alexander, attorney registration number 16757, appearing on behalf of plaintiff appellant Rocky Mountain Hydro Seeding. Seated to the table to my right is Ms. Tina Garsky. She is the principal of Rocky Mountain Hydro Seeding. At its essence, and as reflected in the trial court's order, the basis for this appeal is very simple. Subsequent to the trial court finding, effectively sua sponte, that the subcontract agreement that had been entered into by the parties had been canceled or abandoned because of a lack of written change orders. So subsequent to that, the trial court is reflected in its ruling, and this is on page 616 of the court file. Walsh Construction requested that Rocky Mountain Hydro Seeding perform work, and in response to that request, Rocky Mountain Hydro Seeding did in fact perform work for Walsh Construction. So the question presented on appeal is whether Rocky Mountain Hydro Seeding should be denied any recovery whatsoever as a result of having performed that work because, number one, the theory for relief set forth in Rocky Mountain Hydro Seeding's amended complaint was limited to a theory of breach of contract. And number two, that the trial court found that the subsequent requests by Walsh Construction after the subcontract agreement had been abandoned or canceled were not sufficiently detailed to constitute a new contract between the parties.
Counsel, how is it that the only claim that got tried was the contract claim? In other words, it looked to me like there was an unjust enrichment claim pled at one point. How was that not also tried?
Well, I did not start this case. And so when I came into the case, the complaint had already been amended twice, and the judge was moving things along. And so there's that issue, and quite frankly, and as the party stipulated in the case management order, neither party, neither Walsh Construction nor Rocky Mountain Hydro Seed, believed that there were any claims but breach of contract. So this is something that the court, sua sponte, on its own, raised. It was not something that we asserted or they asserted. But nonetheless, here we sit And so the question is, under Rule 15B, which is how this case is going to be decided, it states in relevant part, and I'm quoting, "When issues not raised by the pleadings are tried by the express or implied consent of the parties, they shall be treated in all respects as if they had been raised in the pleadings."
Is it your, I'm sorry? Is it your argument that all the elements of promissory estoppel and unjust enrichment were established at trial?
Yes.
And where in the record would we find proof of those elements, particularly the elements for promissory estoppel, that the promisor reasonably should have expected would induce action or forbearance by the promisee, and the element of reasonable and detrimental reliance?
Okay, well, as I indicated earlier, in the trial court's findings of fact in its ruling on page 616, and this again is subsequent to the abandonment or cancellation of the subcontract agreement, the trial court found that Walsh Construction requested that Rocky Mountain Hydroseed perform work. And in response to these requests, Rocky Mountain Hydroseeding did in fact perform work for Walsh Construction. There is an implied promise when you ask someone to perform work and they perform work that you are going to be compensated for it. So let me move on to that aspect of it. So what we have here is a request and an assent to that request. So then the issue becomes, we're looking at the unjust part of it, which could cut across to the non-contractual theories of either promissory estoppel or quantum meruit. Okay, and this is what we have there. So in response to the work having been performed, Rocky Mountain Hydroseeding submitted an invoice dated August 28th, 2014 to Walsh Construction. This invoice was in the amount of $5,975, $597.50 of which remains unpaid. The rest was paid. This $597.50 represents retainage. That is Plaintiff's Exhibit 8. That can be found in the exhibit section of the Record on Appeal at pages 74 and 75. In addition, we have Rocky Mountain Hydroseeding's invoice dated December 12th, 2014 in the amount of $38,122.06, all of which remains unpaid. That is Plaintiff's Exhibit 28, and that can be found in the exhibit portion of the record at page 144. So what we have here with these invoices, undisputed facts, undisputed, no objections whatsoever. These exhibits were stipulated to. There were no objections at trial to any of the things that I'm going to go over right now. One is the request for work, performing of work. So it's undisputed that Walsh Construction requested that Rocky Mountain Hydroseeding perform work. It is undisputed that the quantities reflected in the invoices I just mentioned were not contested or disputed by Walsh Construction. It is undisputed that the pricing itemization reflected in those invoices I just discussed was not disputed. And with one exception, which I will get to, it is undisputed that the quality of the work product reflected in those invoices was not contested. So what we have here is, with the one exception which I'll get to, we have two invoices. And in these invoices, we have a total of $38,000 plus, of which the work was performed, not disputed, quantities not disputed, pricing not disputed, and with the following exception, the quality of the work was not disputed. Now, the exception...
Pardon me for interrupting. Counsel.
Excuse me, yes.
In the interest of time, I would like to move on to a more general question.
Certainly.
I've got to confess to you that I am concerned about your position from this perspective. Both sides of this case at one point pled unjust enrichment. Those claims disappeared because they were withdrawn, not because someone forgot about them, but because they were withdrawn. Both parties stipulated that the issue before the trial court was the contract. There was nothing said during the trial to say, oh, by the way, Your Honor, we want to talk about unjust enrichment now, or promissory estoppel. No one said that to the trial court during the trial. No one asked the trial court to make findings about that. And so I'm having a lot of trouble figuring out how these claims were tried by either implied or express consent, because there is no suggestion that they were on the table.
Well, a couple of points on that. Okay, first of all, and this actually touches on one of the points that was raised in the answer brief. Rule 15B says that even if it's not raised in the pleadings, if the evidence establishes a basis for relief, there's no objections to that evidence, you're entitled to the relief regardless of the legal theory or on which it is pled. So if we were to take that kind of a standpoint, that it has to be raised at the trial level in some fashion, you have just rendered Rule 15B superfluous.
But the problem that I see is that the trial court was put on notice that at least unjust enrichment was not a claim. It was specifically told it was not a claim because that was taken off the table by both parties.
Again, if the evidence establishes a basis for relief, Rule 15B, in fact, in Biddle versus Cam, Colorado, the Court of Appeals characterized it as imposing a duty upon a trial court to consider issues raised by the evidence without timely objection, even if the issue is not pled. So all we have here is theories for relief, which were not pled by the time the case went to trial, but the evidence clearly supports it.
I don't want to be argumentative with you, but
Oh, I'm just answering the question, so
I-
hopefully I
I
didn't come
understand.
across that way.
But turning to Biddle itself, in Biddle, it makes it clear that a court shouldn't allow an amendment like the one you're asking for unless there is no reasonable doubt that the issue has been intentionally and actually tried. That's language straight from Biddle. And again, I'm trying to be candid with you and confess my
Mhm.
problem. I don't see how this was intentionally tried.
Well, we have invoices that were admitted. They did not contest the quantities, the pricing, or the quality, with the one exception. If this were a breach of contract action, they would have contested that. If the work wasn't done, or the quantities, or the pricing was not appropriate, they would have contested that.
Counsel, in terms of intentionally tried, do you have a duty to put them on notice at some point during the trial that we're also seeking unjust enrichment and promissory estoppel? Or is that something that when you go back later and you look at the evidence, you then say, hey, wait a minute, this evidence adds up to unjust enrichment or promissory estoppel?
Well, two responses there. One is, if I were clairvoyant and either one of us would have known that the trial court would sua sponte rule that the contract had been abandoned, we wouldn't be here because these would have been pled. Now, the second aspect of that is that my understanding of the case law here is that if issues and evidence are being presented at trial, which are beyond the scope of the claims for relief, the obligation is on the opposing side to oppose and object to that evidence. That did not occur here.
So those weren't part of the contract pleadings, the evidence that you're now arguing supports your claims?
They were part of the contract. They're also part of the non-contract. They establish the amount of quantity, they establish pricing, they establish work quality. And I think one of the other important things to remember here is, look what the effect is, and I think this is precisely what Rule 15 is designed to prevent. The effect in the end here is that Walsh Construction has received, even if you deduct the quality issue that they have received approximately $32,000 in work that they don't dispute the quantity, they don't dispute the pricing, they don't dispute the quality. It is unjust to allow them to retain that work without paying for it. That is the definition of unjust enrichment, and effectively, the verbiage is a little different. That's the same issue on promissory estoppel.
I want to turn to the definition of unjust enrichment. To prove a claim on unjust enrichment, don't you need to show that there was no contract?
Excuse me, I misspoke. Not unjust enrichment, quantum meruit. Right. So that is a non-contractual claim, and based on the findings of the trial court, we are in a non-contractual sphere.
But didn't you concede in the trial management order? In fact, didn't both parties stipulate that there was a contract? And given that stipulation, how can you argue now that there was no contract for purposes of pursuing an equitable remedy?
Well, that was the stipulation. The court found otherwise.
But aren't the
So
parties
we're
bound?
dealing with a trial court which basically overrode the parties. And so we are left with the Rule 15B requirement that the trial court award relief based upon evidence admitted at trial without objection. And I don't think that anyone could say, and I'm down to my last 10 seconds here, that we're unjustment enrichment, or excuse me, quantum meruit, promissory estoppel on the table, we would have got this award. That's what it's designed to prevent. And I've run out of time here, Your Honor, so I better step down.
Thank you, counsel.
Thank you. My name is Nick Orris. My registration number is 29603. And I have to tell you, it's really an honor to be in this building and before you today. I spent the first few minutes walking into the library, and there was the dictionary. I opened it, Webster's Third New International Dictionary, page 2245, and I looked up the word stipulation. And it says stipulation is an agreement between attorneys respecting the conduct of a legal proceeding. And I think back, as we had in this case, a number of different claims when the case was filed. And we go through the process as every trial attorney has, as you've been through that process. And you narrow down what you believe are going to be your claims. As the record shows, that's what these parties did. Mr. Alexander and I, excellent attorney, and he was very gracious during the course of this proceeding. We stipulated that we were going to try this case on a breach of contract theory. We did. We went in front of the judge, Judge Lamons. We told him at the case management conference that this is a breach of contract. We dispute, obviously, who breached it and what the particular terms were, but that's what we're going to try to the court. And we did. We presented our evidence. Their brief makes a lot of statements in there about that I somehow acquiesced in all these exhibits. They were the exhibits that showed the damages for their contract claim, that they performed certain work under the contract, and that was their damage. They were stipulated to. That's what it was, the breach of contract. At no time did we have any discussions on the record by filings of any type that we were going to deviate from the stipulated claims being pursued. Had we, then we could have determined whether we needed to present other evidence as to the benefits or the losses that Mr. Walsh's company received because of the performance, not under the contract, but just by the performance of of Rocky Mountain Hydroseed company. But there was no discussions like that. There's nothing in the record. We presented our case. At the conclusion, Judge Lamons, good order, sets forth his reasoning. But he found that both parties, not one, both parties did not fulfill their contract. Both parties. This is a commercial contract working with the city of Fort Collins on a substantial project. These are sophisticated parties. They know breaches, they know contracts, they have attorneys, they're working with the city under government guidelines. They didn't follow the contract. And he basically said, you're in front of me, you want me to work this out when you were both cognizant of the contract terms, you both messed it up, I guess would be a good legal word. I want to say get out of my courtroom, but that's not what it says. It says that you both breached this contract, you abandoned the contract, you're not entitled to any relief. Neither of you pled an alternative claim. As trial attorneys, I'm not sure of the experience each of you have had, but it's not unusual to plead, as we did in this case, a breach of contract and either an unjust enrichment claim or a quantum merit claim.
Who
Of
drove
course.
that, counsel? I kind of asked that question either. Who drove the one contract claim? Was that driven by the trial court that said that sua sponte said, I'm only going to review this as a breach of contract? Or did the council come together and say, Judge, we only want you to consider this as a breach of contract?
Now, I'm giving you my best gray-haired response, that it was the attorneys that presented that, Mr. Alexander and I.
Okay.
I don't want, that's my best recollection, Your Honor.
Okay, let me ask you this. Setting the theory aside, do you disagree that there was $32,000 or thereabouts worth of work that was requested by Walsh Construction that was performed by RMHS and that was not compensated for?
If we're just looking at the work performed or the benefit received, because I think there's two things, and that's why this wasn't ripe for trial or ripe for judgment. Because did they perform the work? There is no dispute they performed work. Now, that wasn't the totality of the work, and if you look at the record and it's set forth in our brief, I only had 2 points I wanted to argue today. They didn't perform either, okay? And there's certain things that they didn't do. So it's not like we have the golden goose on one side and the bad guy on the other. Hence the judge's ruling, okay? Yes, they performed that work. But Mr. Walsh's company lost substantial money because of the work. If you look at the benefit received, and I think quantum merit focuses not only on did you do something, but what was the benefit received and retained by the person to whom you performed this work. Well, that benefit was not the value that they send in their invoice, because the damages incurred are also exhibits that are attached here. So I don't know whether I would answer your question any differently.
So you had to get someone else to do some of the work,
Well, we did.
for instance?
Yes, AG, it's in the brief. Another company, yes, they performed it. And I think our total damages are set forth in the brief. So this wasn't like somebody made a windfall. Somebody didn't perform, somebody was replaced. The typical breach of contract replacement. And Judge Lamons did it. He went through this order. You know, I mean, it wasn't like the judge didn't pay attention. He just found that both parties screwed up and get out of my courtroom. That's how I read it. But I wanted to quickly, and I don't want to, I forget things. You guys brought up some, you judges brought up some good points. I was reading the Biddle case, which I think one of you had mentioned it here. And it's very instructive because it says, yes, under this Rule 15, you can amend pleadings. But there are some caveats to it. And that was a case where they actually tried it. It was an adverse possession, and the complaint alleged as to one particular parcel, parcel 4, that the complaint alleged that the plaintiffs had adversely possessed certain property that was delineated by fences. Now, that was true for 3/4 of the properties, but one separate parcel, parcel 4, was only bordered 3 sides by fences and one side by a natural barrier. I don't remember if it was a river or a stone wall of some type, but it was not bordered by a fence. But the pleading stated that the plaintiff adversely possessed the properties delineated by fences. Okay? He did not use the word or other barriers. They tried the case, and during the trial, they talked about and admitted evidence as to whether or not that was the boundary. And they talked, I mean, it was admitted, it was talked about, it was tried, it was, they read it, it was no doubt, they tried the case. The court found that there was no adverse possession to that part because they had not pled in their pleadings a barrier, an adverse possession determined by a barrier instead of a fence. And the judge then, and they went to amend the pleadings, right? Let's amend the pleadings so that we can add that barrier. The judge didn't do that. On appeal, the appellate court found that the judge had abused his discretion in that case because, in fact, it was tried. And the part that was read here is, yes, Rule 15 says when issues not raised by the pleadings are tried by express and implied consent, well, then they are treated and you can amend the pleadings. But it's more than that. It says that a district court should grant an amendment only when there is no reasonable doubt that the issue has been intentionally and actually tried. No reasonable doubt intentionally tried. I don't know about you, but we agreed not to try any other issues except the contract claim. That's what we agreed. That's what a stipulation is. Half of our attorney practices are based on reliance. When you stipulate something, as a sole practitioner, I run half my practice based on stipulations and responsibilities and replies from other attorneys. That's how you do your practice. You rely on stipulations. We made a stipulation. We didn't try that, intentionally or otherwise. Where there is no reasonable doubt that the issue was intentionally actually tried. Boom. It's not enough that some evidence has been received germane to the issue sought to be raised. Those invoices were, in fact, the invoices that they had been using to show their breach of contract. The fact that they also showed the claim for unjust enrichment or quantum merit, I will give you that. Had they presented a quantum merit or a unjust enrichment claim, we would have provided additional evidence to defeat that.
Are there circumstances under which a party can withdraw from a situation, and specifically, do changed circumstances justify withdrawal from a stipulation?
I believe so, sure. And had those arose during the course of the trial, absolutely. He could have said, Mr. Alexander could have come to Judge Lammons or myself and say, you know, we're halfway through this trial and this breach of contract claim looks like it's really an unjust enrichment claim. Raise it at that time. Raise it when we're putting on the evidence. Raise it when the case is ripe. In fact, you know, this case is one that had discovery, it had depositions, it had a stack of papers. I don't know how big. It wasn't just, we didn't just show up in court someday and say, hey, you know, we breached a contract. No, you didn't. You know, there was a well put together case. And whatever Judge Lammons determined, he apparently believed that both parties were, in my opinion, in reading his order, both parties were equally at fault in breaching this contract. Yes, Mr. Walsh did request. They have equal ability to say, hey, I want a written change order. I'm not going to do it. Won't put one seed in the ground until your signature is on a piece of paper that says I get paid for it. That's the way commercial contracts are generally, in my experience, commercial contracts are very, and contractors are very hip on using written change orders so we don't end up with the mess that was presented to Judge Lammons. And so I hope I answered your question. If we had a need to change the stipulation, yes, stipulations change. Or if they were founded on facts that were later determined to not be correct, you can change. I mean, I stipulate that it's blue, but we turn out that the car's white. I mean, I don't know how to answer that question anymore. That yes, stipulations can be changed, but there was nothing in this case up until.
So subcontractors can't rely on the contractor coming to them and saying, I'd like some additional work done. They need to go back to the contractor and say it's got to be in writing first. Is that what you're saying?
Well, that's a real tough. I would imagine that a lot of work is done without having a written change order. I would concede that, even in, I don't know in the record, I don't know what I'm supposed to say, but in my experience, there are a lot of changes that are made to contracts in the construction law that don't follow exactly the terms. But on those cases, those individuals, I believe, take the risk of operating in that arena. But when push comes to shove, and there's a legal pushing match, I want paid, no you don't, you know, you're in a better position, of course, had you had the written documents. In this case, I'm not so sure what it really would have, because if it boils down, if you read the contract that's in the record, this was a contract that was based on the materials that were installed. If they put in the core matting, he would pay to Ms. Hart's company so much dollars per square foot. If they put in this, there were three seed mixtures and maybe 2 types of matting. In other words, it was the same materials. It was just whether or not they were going to put in X amount of pounds of this seed or X amount of pounds of that seed or X amount of square feet of this type of matting. It was all by this quantity. And so from my client's perspective, it didn't matter what, because you were paid based on the quantity of which you installed. These are the same materials, it's just different quantities. And that's the thing that was changing. If you'll look in Judge Lamon's order, Mr. Walsh testified at trial, well, I don't really see the need, I didn't deem it too important to have a new contract because it was all based on quantities. Now, there is a footnote in the judge's ruling where he says, you know, we don't agree. He disagreed with Mr. Walsh's contention. So that's what the court determined. But from our perspective, it didn't matter whether they put in 1,000 pounds of bluegrass or 1,000 pounds of native grass. Whatever was installed is what you're going to get paid for. And so the contract, yes, it was delayed, it was changed, it was times, but it was really how much square footage of this material versus square footage of that material. It was the same materials. And so there was a little bit of the Judge Lamons did not accept that as the contract. But in response to you, Your Honor, yes, there are contracts that have required change orders, and I'm sure it's done every day in Colorado. But I find it would be very difficult handling construction cases and residential construction cases especially. When there are no change orders, I think you run the risk, as the company does, okay, we didn't have the change order. The judge threw out the contract. You know, this isn't somebody that just does landscape. These are sophisticated companies, sophisticated individuals.
Pardon me for interrupting, counsel. Your time is over.
I'm sorry, Your Honor. Thank you very much, and I hope I made some sense. Thank you.
Counsel, thank you very much for your arguments today. We appreciate them. The case will stand submitted. An opinion will issue in due course. I know both of you are from the northern part of the state. It's going to be rainy this evening. Please drive safely home. The bailiff may announce the recess.